Senator Byrd.
Thank you, sir. Quick question, if that's okay. Thank you. My experience with this honestly has been that sometimes a child needs to be removed from a home, and it is near impossible to get that done. Can you assure me that this will do nothing to affect the ability to take a child out of a home if that's what is needed?
It does not affect that. All this does is it gives the prosecutor a tool in their toolbox to deal with cases as they see fit, and that's pretty common. With prosecutorial discretion is a pretty standard way of dealing with any sort of prosecution. So I don't really think that would change that.
Thank you for that assurance. I appreciate it.
Seeing no further questions, we got a motion and a second. Oh, Senator Neal, go ahead. Last question.
I have multiple. Oh no. Thank you very much for bringing this. I just want to make sure I understand it because I have a concern too. Sometimes the person that's under scrutiny in this scenario could agree to a course of action, which one party could leverage their relationship to reach that agreement without the prosecutor involved, other than when they go to the prosecutor. And then there could be a situation where they should be removed. And it raises the same question that I think I'm hearing over here, because in my experience, a lot of these situations, people feel remorseful about, the relationships get complex in terms of how they make decisions and so forth. And sometimes somebody just has to step in and make a decision on behalf of the child. So I'm just trying to see, does that give room for the scenario I just described? Or?
I mean, I guess perhaps it could, but I believe this is when an accusation is brought and their kids are removed or a child is removed, they either admit that it's true. Sometimes the courts will allow them to stipulate to just general substance abuse or state that the child was put at risk of harm, which is that's kind of just an umbrella type thing that would cover just about all situations, or they have a hearing. So, and the reason I think this is good for the person that's accused is it would allow kind of a softer approach. If the prosecutor feels that this is not a person that has a bad background, and if they feel like it's appropriate, this would be a softer approach. There would still be a case plan that they would have to work. But as long as they work that case plan and they follow that, they're not going to kind of have this long term with them. So, I mean, I feel like overall it's a win for the accused, because it allows, under the law, an ability to kind of take an alternate route on this. And just to be quite frank, this situation is, I guess I would say is fairly common practice in some circuits. Nobody really says anything about it because then there's no person that really objects to it. So, and really what this would accomplish is actually have statutory authority for an agreed plan. Just parties could enter essentially an agreed order. They work the case plan. If the case plan is not followed, then the prosecution could revoke, and the judge could review what has or has not happened.
So I apologize, but just real quick. If I understood from your testimony, you already have this discretion.
No, it's not. There's not. You
do not have this discretion.
But I'm saying
there's nothing prohibiting it. So you've got some circuits that are sort of informally doing something similar to this already.
Yeah. Okay.
And as he said, and I don't want to speak for you because you're capable of speaking on your own, but in the interest of time, the reason it's done is because no one's objecting to it.
Yeah. And this formalizes kind of the informal adjustment process and sets forth the parameters where the AOC could have a form. The judge could have a checklist, say this happened, and you're not just doing it on the fly.
Thank you so much. Appreciate it.
All right. Seeing no further questions, We've got a motion and a second on the bill as amended by the sub. Mr. Secretary, please call the roll.
Senator Berg,
Aye.
Senator Carroll,
Explain my aye vote.
30 seconds or less.
I'd still like to hear from our CACs, but I will vote aye.
Senator Kerr,
Aye.
Senator Neal, Senator Schickel, Senator Schroeder, President Stivers, Senator Turner,
Explain my vote, Mr. Chairman.
Yes.
I appreciate this bill coming forward. It's a long time coming as a person has practiced it since this court process was established. You have, as a school board attorney, you get a kid that gets just a little bruise on it. It's got to get reported, and you take up so much time with the court. Social services will be tickled to death with this. But if you read the first part of it, says, in determining the disposition of all cases brought on behalf of dependent and neglect abused children, the district court. So it's mandatory that the district judge be involved in this. So it's not a process that somebody may worry about that there's going to be somebody slip through the system, because it's just a process to streamline it, get it done, get it out of the system when it doesn't need to be really one that's prosecuted and goes so long. So I appreciate and I vote aye 10 times on this thing. Thank you, Mr. Sir.
Senator West,
Aye.
Senator Wheeler, Chairman Westerfield.
I vote aye. Bill passes with favorable expression, I believe, 8-9 to 0. Motion and a second for consent. I heard Schickel and Wheeler, I believe. All those in favor, please vote by saying aye. Aye. Those opposed? Okay. If it makes you feel any better, and we won't put it on consent, but I want to. The CACs aren't ever involved in, at least in my experience, they were never involved in dependency, neglect, and abuse cases. Unless there was a criminal companion case that's pending, they're certainly involved and handle those things, but not in this. All right. It's 9-0. Will not be on consent. Thank you, Representative. I appreciate it.
Thanks, sir.
Representative Beckler, come on up. House Bill 472, an act relating to child abuse and declaring an emergency. And members, there is a sub on this bill as well. I'm going to let Representative Beckler explain the underlying bill, and then I'm going to explain what's in PSS 2 that you should have in your folders. All right, Representative, you have the floor, sir.
Thank you. Chair Westerfield, Vice Chair Carroll, and members of the committee, thanks for allowing me to present House Bill 472. As the chairman said, a bill addressing the sexual abuse of minors. The thrust of the bill is to increase the time allotted for prosecution to 10 years from what is currently 5 years. We'll talk about the committee sub later. Sexual abuse of any kind is abhorrent, but sexual abuse of minors is not only abhorrent, but also incomprehensible to me. My goals with the bill are to help victims and hold perpetrators accountable for their heinous crimes. Mr. Chairman, I have a person on Zoom to testify. Do we want to go to her?
That'd be fine.
Okay. At this time, I ask that Lauren Bessignac be allowed to testify.
Lauren, are you with us?
I'm here, yes.
You have the floor.
Thank you. So I will preface, I am actually on call again today, so I may have to jump off here pretty quickly after. But hello and good afternoon. I have shared my testimony a number of times now, but it's something that I feel bears repeating. So again, my name is Lauren Bessignac, and I am the Pediatric Forensic Nurse Senior for the Division of Pediatric Forensic Medicine at the University of Kentucky. And while I am here today to represent myself as a pediatric forensic nurse, for University of Kentucky, however, my statement today does not reflect the views of University of Kentucky. So as a pediatric forensic nurse, I work alongside a team of amazing and compassionate medical professionals who really meet children at a time when their innocence has been stripped from them, after being sexually abused. Professionally, I have seen how heavily the reality of what it means to not only disclose, but to press charges and move forward with prosecution, and how heavily that can weigh on the child and a family. It's not an easy decision to make. I also understand this personally as a survivor of child sexual abuse. I was around the age of 3 when the grooming and the sexual abuse began. It stopped when he finally moved away around the age of 6 or 7 for me. Then at the age of 11, I had what was kind of a light bulb moment when I realized, thinking about all male grown-ups don't necessarily do this. They don't necessarily have the secret touching and the exposure to the male anatomy. I realized that that was not something that was normal. Then suddenly I'm overwhelmed with feelings of shame and guilt. I remember that really like it was yesterday. And I carried, those feelings with me for many years. And yet I still didn't disclose until I was 17 years old. My sister, who was also a victim, she didn't disclose until she was in college. We both felt very angry, dirty, and guilty. But most of all, we were terrified that our parents would blame themselves, as if somehow they should have known what was going on, because they didn't, because that's how predators work. My story is not uncommon, and too many are preyed upon. And the impetus for seeking justice and peace for those who've fallen victim, even after me, is stronger now than ever before. This bill is so important, as often children don't understand what's happening to them in that time. House Bill 472 would give the victim more time to seek justice. And now, on the eve of my 40th birthday, my hope is that we start holding adults accountable for their adult actions and allowing the victims the chance to be heard. So I thank you for listening, and thank you, Representative Beckler, for allowing me the opportunity to speak with you all today. And I hope that you will vote in favor to this bill.
Thanks for making time while you're on call. I appreciate your work, and I appreciate
Absolutely.
you making yourself available for us this morning.
Thank you, Lauren.
Representative Beckler, do you have anything to add? I was going to explain.
She says it all.
She does. There is. So the substitute members makes a couple of changes. The bill as it came over from the House had a reviver provision in it that you could read to allow the revival of claims, even previously time-barred claims, going back as far on the calendar as you thought you could find a case. The committee sub limits that to the 5 additional years. So the 10 years that's consistent with the language, not only in this bill, but in existing law with regard to civil claims. So this tracks with that, and it caps that reviver at 5 additional years. Importantly, one other change in the insurance industry, which still objects to the reviver language, but they requested that Section 3 in the bill that came over from the House be stricken. That was a 1-sentence, 2-line section of the bill that allowed insurance companies to not, that they weren't obligated to provide coverage for certain conduct. I assumed they would prefer that. They didn't like that for whatever reason, so at their request, I have taken it out. That is in the Senate substitute before you. Got a motion from Senator Schickel, second from Senator Neal. All those in favor of adopting the sub, please vote by saying aye. Aye. Those opposed? All right. Got a motion from Senator Neal, a second from, I think, Wheeler. Any questions, further question or comments, Senate President?
Yeah, thank you, Mr. Chair. I walked in on the very end of this, but I've had discussions with the chair over the weekend. So what this is going to do, if there is a statute of limitations prohibition currently, so we're in the 6th year, that's not going to be revived. But if you are at 4 years from the date of the event, you will actually have now 6 years from that point in time.
Thank you, Mr. President. You're half right.
Okay.
If it's 4 years and 364 days when this is enacted, you've got an extra 5 years. But this also revives the previously time-barred claims just in that prior 5-year window. So instead, you can't bring a case from
15
6
years
years.
ago.
Right.
15,
or even 6 years ago.
right, because you're outside of the current 5-year statute limit.
That's correct.
I may have misphrased because that's what I'm looking for. If it has been 6 years ago, you are currently time barred, and so it would not apply to that. But if it is less than 5 years old, then you would have
more than 10 years. Excuse me, I should say that. If it's more than 10 years, you said it right, and I restated my answer wrong. We are reviving previously time barred claims.
To what extent?
Just for the 5 years beyond the 5 that we're in. So 5 years back.
Okay. All right. I just
In the 6 to 10 range.
okay.
That.
In the 6 to 10 range. Okay. You think that'll be challenged?
Well, I think it might be challenged, but I also think, and I know we've got some folks from the American Tort Reform Association.
And I'm not opposed to that.
Sure.
You know, but I understand that somebody may wind up with a challenge to.
And importantly, and it came over from the House this way, there's a severability clause in the bill. So if that particular part is challenged successfully, so be it. But I also think there's some evidence or some, and we've passed things, and I mentioned this to you over the weekend. I mentioned this with the sponsor, Representative Beckler. You know, a few years ago, we passed a bill, Senator Parrott, DUI look back bill, that extended that look back period from 5 years to 10 on enhancing a future DUI offense, which does the same thing. It revives previously time barred prior convictions for use in a subsequent charge. And to my knowledge, that has not been challenged. In fact, I think it's been upheld.
It has been upheld.
So I think what we're doing is a modest change and a limitation, a restriction on what originally the House passed, but still celebrates both the intent and the spirit of the bill, and does so in the most limited way possible without abandoning those claims altogether.
Okay.
We got Senator Turner and then Senator West.
Just a comment. I think the rule is if the statute says it is authorized to look back, it's okay. You got to make that part of the statute. That's the problem in the DUI bill. It just says.
Senator Berg, did you have a question? And then Senator West.
My question has to do with neither the husband, wife, nor any professional client patient privilege except attorney-client and clergy penitent privilege shall be grounds for excluding. I'm a little concerned that therapists are going to have to say, if somebody starts a discussion along these lines, wait a second, stop, anything you tell me, you have to know that I'm obligated to present this to a court of law. And that bothers me. I think that's a chilling effect for people who are seeking professional help. So I would like somebody to look into that and address that concern for me. Because if you have either a survivor of abuse, or perhaps a family member who is concerned about the possibility of abuse, and they go to a therapist and want to discuss this, I mean, that could be really chilling if they know that's not privileged. So that's my concern.
Representative, you're free to-
If I'm not mistaken, this part is actually not a change. If you go to a counselor, if that counselor finds out that you've done this, I believe you're required to report it anyway.
Can I ask a follow-up question?
Yes, ma'am.
What if the counselor, you're not admitting to sex abuse? You're admitting to a concern that somebody in your family may be. I mean, I just think there's a lot of room here for people not being willing to discuss something along these lines if they know that it's not privileged. I mean, can we just not include professional client patient privilege unless it's waived?
If I'm reading it correctly, it still requires there be an exception to the rules of evidence before it can. I'm reading, this is page. page 5, line 2 of PSS. Well, I'm looking at PSS 1. PSS 2, it should be on the same spot.
I'm not an attorney, as you probably all would have guessed by this time. So I'm very, very happy that I have worked with a number of attorneys beforehand. But as the chairman was saying, it says, neither the husband, wife, nor any professional client patient privilege except the attorney-client and clergy penitent privilege shall be ground for excluding evidence regarding childhood sexual abuse, assault, or abuse, or the cause thereof when an exception to the Kentucky rules of evidence is met, as the chairman pointed out.
As long as you have that covered for me, thank you.
Senator West.
Yeah, maybe some people, the attorneys on the committee can answer the question, but it was my impression that criminal conduct is not protected by professional privilege in those types of situations. So, for instance, if you've got you have a rape and you've got a counselor and there's an investigation, that the prosecutor is allowed to discover that evidence from the counselor. Is that your all's impression? That was my impression. What I'm saying is I think this is covered now under current law.
I don't want to try to take a stab at that. I know that there's a duty to report in certain circumstances, but with regard to criminal conduct generally, I don't know.
Well, in this case, what we would be discovering is evidence of abuse and neglect.
That's right.
So what I'm saying is I don't think this is much different than how things currently occur.
Lauren, do you have any comment? If you've heard the discussion?
I haven't looked.
I have. I don't know that I can speak to the legality.
That's fine.
I'm most familiar with, the duty to report. And I will tell you that actually that's how it was reported when I was younger, was because my parents put us straight into counseling, and that was the person that reported it. And then it was investigated. So I don't think that it is any different than what currently is in place.
Thank you.
I'm going to go ahead and let the gentleman from the American Tort Reform Association speak briefly, if you don't mind, if he or she is with us. I think it was a gentleman, but I can't remember now.
Hi, good afternoon. Good morning, Mr. Chairman. My name is Kerry Silverman. I'm here on behalf of the American Tort Reform Association. Can you hear me okay?
We can hear you and see you. Go ahead, Kerry. Thank you.
Thank you very much. Thank you for the opportunity to testify today and express our concern to certain provisions in this bill, HB 472. My name is Kerry Silverman. I'm here on behalf of the American Tort Reform Association, which is a coalition of businesses, municipalities, and associations that support a balanced, predictable, and fair civil justice system. I'm an attorney at a firm called Shook, Hardy & Bacon, where I've practiced for 20 years, primarily in the product liability, consumer, and appellate law. I'm also an adjunct professor. I respect the courage of those who are going to testify in support of this bill and the proponents of this legislation. ATRA has no issue with lengthening the time to bring a lawsuit for injuries for childhood sexual abuse against anyone, or applying that longer period to lawsuits against organizations for which perpetrators were employees or volunteers. Our main concern with the bill as drafted is its revival of time-barred claims. With any statute of limitations, we believe that Kentucky should adhere to the fundamental legal principles that govern all civil claims, and that is, that statutes of limitations, one should be a finite period of time to file, and that changes to the limitations period should be made prospectively, and they shouldn't revive claims after the time to file them has ended. The reviver in this bill strays from those principles by reviving any claim that was barred because the statute of limitations expired during a 5-year window period. And ATRA's concerned with the approach and the precedent that this type of provision provides for other types of claims in the future. And I understand that some may view statutes of limitations as an arbitrary time to bring a claim, and others may consider them as just a way for defendants to avoid liability on a technicality. But the core reason that we have statutes of limitations, which can be overlooked, is to make sure that judges and juries can make decisions about liability based on the best evidence available. They protect accuracy and reliability in the civil justice system, and that's particularly important when a jury has to evaluate what an organization did or didn't do, or shouldn't have done at some point in the past. And for childhood sexual abuse claims, you have set a statute of limitations that's longer than other types of claims. 10 years of becoming an adult, of the conduct of when the victim should have known of the abuse, or 10 years of a conviction. And if those periods aren't long enough, they can be extended. They can be clarified to apply to organizations in addition to perpetrators. As I said earlier, we have no concern with doing those types of measures so long as they're done prospectively and there's a finite period of time to bring them. But the problem with retroactively allowing lawsuits dating back what could be decades, and I understand there have been some potential changes here that may limit the applicability of the bill, but I'll speak on that in a moment, is that in many cases you may have a perpetrator that is dead, that the employees who worked at the organization are gone, and any records, because there was no inkling that there would be liability, have been discarded along with whatever document retention policies were set, and may be set in accordance with what the statute of limitations was. And whether the entity is a daycare center or school or another program, the ownership or management may have changed hands. And a jury is going to be faced with a plaintiff who no doubt experienced abuse, and then has to decide whether a nonprofit, a business, or a government entity took appropriate steps in how it hired or supervised an employee or volunteer, or whether it had adequate measures to detect abuse with little or no evidence available to it. And that liability is going to be evaluated in hindsight based on what we know today and the safeguards we expect today, rather than what was known and expected decades ago. And that's precisely why we have statutes of limitations and we don't change them retroactively. We're very concerned about the precedent this sets, continuing down this path and reviving time-barred claims of any kind. It's understandable to view childhood sexual abuse as involving such horrific conduct that there should be an exception to the rules that apply to other claims. But tort law, as a defense attorney, we see cases that address catastrophic lifelong injuries all the time, cases that involve a medication that allegedly caused a child's birth defect, a defect in a car, or a drunk driver that caused an auto accident that may have killed an entire family, or people that develop cancer due to exposure to a consumer product or a medication, just for example. And there's many other areas where statutes of limitations will seem unfair and arbitrary when viewed in an individual case, but we need to consider the broad public policy reasons why we have them. And if we set aside a statute of limitations here, you can expect others to seek similar treatment for product liability claims, environmental claims, and endless others. We're already starting to see that slippery slope begin. And as mentioned earlier today, not only is reviving time-barred claims problematic from a public policy perspective, as I said, it also may be unconstitutional. And I'm not a Kentucky lawyer, but I've spent some time before this hearing researching whether Kentucky's constitutional law is consistent with most other states. And most other states recognize that a legislature cannot take away vested rights, which includes reviving time-barred claims. Now, there are exceptions in some states, but this is not a state where we have those exceptions. And what I found that is for well over a century, the Kentucky Supreme Court has consistently said that a legislature can extend the period to file a claim before a statute of limitations expires, but it can't permit a claim once the time to file it has run. And that's a principle that's actually important for both plaintiffs and defendants. It protects plaintiffs by allowing the legislature, by not allowing the legislature to retroactively shorten the statute of limitations. Say a future legislature came in and changed the 10-year period you have to 5 years, moved it back again. and take away a plaintiff's cause of action. You can't do that. That's unconstitutional. And the same flip side of it is for defendants, it means that once the time to bring a claim has ended, the legislature can't revive that claim.
Mr. Silverman, I'm going to stop you and ask you to wind it down here.
Sure, I'd be happy to. Just one more moment, Mr. Chairman. Just contrary to what you may have heard, most states haven't taken this approach. About a third of states have revived time-barred claims, but most of those states have had significant limitations on the revived claims, limiting them, for example, to perpetrators, to knowing or criminal conduct, to gross negligence. There's no constraints in this bill like that. This is the longest window period we've seen in any state but Hawaii, in terms of which had a 2-year window and had extended it several times. And I also feel, Mr. Chairman, I can go into this in more detail if you'd like. There are several provisions in the draft of the bill that I've seen that I think need significant clarification, that are uncertain as to whether they're creating new causes of action, the length of the reviver still, and the applicable liability that is under this bill. Thank you. I would welcome your questions.
Thank you, Mr. Silverman. President Stivers.
Thank you, Mr. Silverman. I have a question for you, several questions. I'll try to be brief on each one of them. But for insurance carriers, there is generally a prohibition and an exclusion for criminal acts. So if one has a policy and the entity or the individual gets sued, they may have individual liability, but most policies have that exclusion for criminal conduct. Am I right?
I'm not an insurance lawyer, but I think that is accurate.
I think it's pretty accurate too. And so for, let's say, if you're wanting entity liability for an individual's actions, you would have to show, and I'm going to use this in the case of an employee who commits child abuse, you would have to show that the entity knew or should have known that its employee was doing that to make entity or employer liability and was negligent in not stopping it. The second scenario is if the employer knew that the employee was doing this, i.e. the Explorer's case, and specifically helped cover it up, that's a total separate and distinct cause of action, again, which I think if it was just lack of knowledge, lack of supervision, that's a negligence claim. And the carrier would be responsible. But if there was a concerted effort to conceal, which in and of itself is a criminal act, that exclusionary provision would basically keep the carrier from having liability. So two different scenarios.
Yes, I'll agree with that, Senator Stivers. There are two types of claims. Negligence claims are going to be the ones that are easier to meet and involve a broader range of conduct. And there are going to be claims that may allege intentional torts where an insurer may have a defense that the policy coverage would not apply.
Yeah, and they would defend under reservation of rights. Okay, that's all I have. Thank you.
Thank you. We're going to call an audible. It's that time in the session. You know how we have those scenarios. What happens if the president's gone and the vice president's gone? That's what we're experiencing now. We have our chairman out presenting a bill. We have our vice chairman out presenting a bill. Now I'm in charge. As a former vice chairman, they've allowed me some leeway here. So we're going to table, Representative Beckler, we're going to table your bill momentarily. So if you would stand at ease on House Bill 472, and we're going to, is that okay? Mm-hmm. We're going to bring Representative Moser up and let her start her presentation on House Bill 497. If you would, please.
Mr. Chair, while she's approaching, there is a motion, correct, on the bill as amended by the sub.
There is a motion on the sub. Okay. Correct. Yeah.
All right.
We're tabling that motion and that or momentarily. We have before us Representative Moser, House Bill 497. Please proceed.
Thank you very much, Mr. Chair and committee. And I know this is a very busy time. We're all shifting back and forth, trying to get things done at the last minute. But this is a very good bill. I am Representative Kim Mosier for the record, and I do have some guests with me whom I will allow to introduce themselves.
Good morning. I'm Kate Shanks, Vice President of Public Affairs for the Kentucky Chamber.
Good morning. I'm Cody Angel. I'm an individual affected by the criminal justice system.
Thank you very much. So I don't think that this will take that long. This is a bill that addresses lifting barriers for incarcerated individuals who are reentering society. We know that for many
Representative
reasons.
Mosier,
Oh, we do have a committee sub.
this is a very unusual time in session. You have plenty of time.
We're on the floor in
So
10 minutes.
we do need to discuss, do we need to adopt the sub?
Committee sub.
We have a motion. Do we have a second? We have a motion and a second. Let's call the roll.
Voice.
I'm sorry, voice vote. All in favor? Opposed? Ayes have it.
Thank
Please
you.
proceed.
All the committee sub does is cleans up language for AOC in terms of the documents that are given to the incarcerated individual. Just strikes the language that it said on in section 1, sub 1A, to be provided by the administrative office of the court at no cost to the department. They were not sure that they could make that happen, but they are very willing to work with us and the local jails. And then section 2, it just adds a provision that includes a curriculum on employment. This is something that they use in various jails. We just want to standardize this. It's very popular, apparently. So for many reasons, we know that individuals who are incarcerated lack skills that are necessary to reenter society and function as productive members of society. And in families, this legislation seeks to encourage individuals to gain the skills and the education necessary to enter the workforce and to reintegrate. Excuse me, I'm trying to go fast. This will help individuals obtain the documents that are essential to gaining employment. It will increase individuals' confidence through job training and resume building, and it incentivizes employers to give individuals opportunities and be the second chance employer by providing limited liability protections for the employer while ensuring that individuals can then provide for themselves and their families.
Mr. Chairman, if it's in order, I'd like to place a motion to adopt the bill or pass the bill.
The sub has been adopted.
Yes, it has.
The committee will stand at ease. Senate President's going to make a motion.
Mr. Chair, to clean up the record, since we didn't appropriately do some things earlier, I'm going to move to reconsider the vote by which the adoption of the committee sub was taken. At first, asked Senator Schickel to withdraw his motion for favorable passage.
Withdrawn.
Now I would move to reconsider the vote by which it was taken to adopt the committee sub and to basically hold that in abeyance until we take care of something else on Mr. Beckler's. So I take a voice vote to move to reconsider the vote by
Second.
which.
We have a motion. We have a second. We have a voice vote to move that motion forward. All in favor, say aye.
Aye.
Opposed, nay. Ayes have it.
Okay, now I have another motion. I would move to table House Bill
472.
which would then allow us to move forward and consider the representative's bill.
Motion to table 472. Do we have a second?
Second.
We have a second. Voice vote. All in
Aye.
favor, say aye.
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 Those opposed, no. Ayes have it. So, 472 procedurally is officially tabled. So now we have before us House Bill 497. Is there a motion on the sub? We have a motion and a second on the sub. That's a voice vote. All those in favor say aye.
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 Ayes have it.
And I also have a motion on the bill.
There we go.
We have a motion on
Second.
the bill. We have a motion and a second. We will slow it down just a little bit here. Do you have other people wishing to testify first? One moment. What we're going to do is we're going to allow more testimony if they want, and then we'll come back for questions. Okay. Gotcha. Okay.
Yeah, I want to say something.
We'll go ahead, statements and questions. Senator Schickel, then Senator Berg.
I looked over this bill over the weekend, and I think it's a great bill. It's a very common sense bill, which I like, and I think it's just total common sense, and I love it, and I think it's a great bill, and I'll be enthusiastically voting for it, Mr. Chairman.
Thank you, Senator.
Senator Berg.
Thank you, sir. And Representative Mosier, I would like to echo what Senator Strickler just said. I think this is a great bill, wonderful bill. I think it's something needed. I would love to add that we have to have their eyes examined and give them glasses before they get discharged so that they can actually get their driver's licenses and get to work. But that's not my question. My question is, under this little section, the department shall provide an individual whose certificate of employability has been, no. Okay, before it. The department shall revoke the certificate of employability provided under this section of any individual who is convicted of a felony after receiving a certificate of employability. I'm hoping that this addresses an issue that I brought up, in that we are taking prisoners here in Kentucky. We are training them while they are incarcerated to be EMTs. And then upon release, they automatically have to give back that certificate. They are not allowed to practice as EMTs because they have a history of a felony conviction. So if they get their certificate after their conviction and they don't get another one, would this protect them?
That is an interesting question. Thank you for that, Senator. The revocation section in this bill, I think that there are two issues. I think that there's an earlier section of the bill that talks about if a person has a certain crime, has committed a certain crime. For example, if they were a healthcare professional with a substance use disorder, this does not preclude them from it doesn't preclude them from having to deal with that issue separately. Does that make sense?
Yes.
So they can still get a certificate. As far as revoking the certificate, we didn't specify, we weren't explicit about any particular training per se in this bill. So I don't think that this bill would cover EMTs specifically.
I mean, but isn't the goal that if somebody gets training while incarcerated, here we're helping them
Right.
with a resume, with their skills, with, I mean, it seems like it would be what I want it to be.
Right, right. And I think I understand your concern. And I would agree that if someone's gone through the training, that we wouldn't want to automatically revoke that training just because they were incarcerated. So I don't know if this, I don't think that this would repeal any sort of law that pertains to that particular issue. Does that make sense? Okay.
Senator Schickel. Okay. Question has been called. Thank you, Representative Moser. Please call the roll. We have a motion and a second on the sub.
Senator Berg,
Aye.
Senator Carroll, Senator Kerr,
Aye.
Senator Neal, Senator Schickel.
I'd like to explain my vote.
Please proceed.
Thank you. I just want to say something about the question that the senator brought up about EMTs, because we're looking at that in the Licensing and Occupation Committee. That's probably out of order, but
Senator Schroeder.
Mr. Chair, explain my yes vote.
Please proceed.
Thank you, Representative Moser. Happy to support your bill today. I just feel like I need to say to your witness, Cody Angel, thank you for reminding me today how inadequate of a deer hunter that I am. But despite that reminder, I'm still in favor of the bill. Thank you.
President Stivers. Senator Turner.
Explain my vote. Aye.
Please proceed.
I would hope under Section 10, where it says the department shall notify incoming prisoners of the possibility of earning a certificate of employment, that they do that in writing and present this document to them, or the document that they prepare, and give it to them so they can read it, so they'll know then that what challenge they've got to do while they're in there. Thank you, Mr. Chairman.
Senator West.
Aye.
Senator Wheeler.
Mr. Chairman, I vote aye. Explain my vote. I think this is a very good bill that helps people reintegrate, and I'm very glad you brought it. So
Chairman Westerfield.
The vote is 9-0, unanimous. Does the bill sponsor want this on consent?
Consent would be wonderful. Thank you.
Great. Okay. We have a motion and a second on consent. You may. Just to fit, we're voting now on 497. It has passed unanimously.
Okay.
And we're considering consent.
Okay. And Mr. Chairman, I apologize. I had to present a bill in another committee. Representative Moser, Chairwoman Moser, communicated with you last night and this morning and expressed some concern, and maybe you all have already talked about this, but I understand that this is a simple document that's really nothing more than a record. My concern is from a employer's perspective is, where is this road leading in the future? And I'm very sensitive due to the nature of work that I do away from the Senate, in that I have to be very, very careful of who I hire, because these are folks that are taking care of a very vulnerable population. And I worry that down the road that this provision will grow into more, and there will be more requirements that convicted felons be hired, and that there will be these types of documents perhaps being used against an employer for not hiring. And I know as this stands right now, it is very simple and it's really nothing more than a record. But I worry about where this might be headed in the future. Can you address that, please?
Sure. Thank you, Senator. I understand your concern, and I'll let Kate Shanks from the chamber weigh in. We have worked with DOC, AOC, KJA, the chamber, and I haven't had any concerns from employers, from an employer standpoint, in that regard. We have discrimination, anti-discrimination laws currently that would not relieve employers from discriminating, but this also gives employers some protections in hiring. I don't really see that this in any way would force an employer to hire someone. We're just looking to lift barriers to allow folks to get back on their feet after being incarcerated. So I don't know, Kate, would you have any further comments?
And Mr. Chair, she was texting me because she's going to be testifying in my committee here soon, so she may have dropped off.
That's true, right. We did talk about this earlier, Kate and I, and we haven't had any concerns from the employer standpoint. There's nothing that in here that compels an employer to hire anyone.
And I don't argue that. I agree with that completely. But again, the road starts with the first step, and I guess that's kind of what concerns me is what's going to be coming next year and the year after. And as an employer that's very sensitive to this, how much strength will this gather over the years, and how much more pressure will be put on employers who have a very sensitive clientele to hire folks that are out of prison, and that's what worries me with this. And Mr. Chairman, I would like to cast an aye vote to move the bill, but I would be a no vote as far as consent.
That is in order because you arrived in time for the concurrence vote. So the bill will not go on the vote. The bill is passed, but will not go on concurrence. Thank you, Representative Moser.
Thank you.
Appreciate it. And thank you for dealing with the moving parts
It
today.
is no problem. I completely understand.
The real committee chairman will now be back and take over and deal with the business on the table.
It's not too late to trade. Mr. President, if I understand correctly, Senate Bill or House Bill 472 has been tabled. I'd make a motion that we remove it from the table.
Second.
Mr. Secretary, would you please call the roll?
Senator Berg,
Aye.
Senator Carroll,
Aye.
Senator Kerr,
Aye.
Senator Neal, Senator Schickel, Senator Schroeder,
Aye.
President Stivers, Senator Turner, Senator West,
Aye.
Senator Wheeler, Chairman Westerfield.
Aye. Bill is back in front of us. Now, procedurally, we've got a motion and a second on the bill. Do those remain?
No, they do not.
I'll need a what about the motion and the second on the sub?
It's been done away with.
Let's.
I'll make a motion, Mr. Chair, on the sub.
Motion from Senator Schroeder, second from who? Me. Senator West. All those in favor of adopting the sub, please vote by saying aye. Aye. Motion on the bill.
Mr. Chair, motion on the bill.
From Senator Schroeder, second from Senator Turner. Seeing no further questions, and it having been debated at great length, and I appreciate everyone's patience, Mr. Secretary, please call the roll on House Bill 472 as amended by the sub.
Senator Berg,
Aye.
Senator Carroll,
Aye.
Senator Kerr,
Aye.
Senator Neal, Senator Schickel, Senator Schroeder,
Aye.
President Stivers, Senator Turner, Senator West,
Aye.
Senator Wheeler, Chairman Westerfield.
Aye. Bill passes with favorable expression 10-0 if my number is correct. We will not put this on consent. But congratulations, Representative. Thank you.
Thank you. And I appreciate everybody's time and vote. Thank you very much.
I appreciate everybody's patience as we had to work through everybody's multi-committee juggling act this morning. Unless something unexpected happens, I believe we've just finished our last judiciary meeting of the session. But never say never. That's right, unless. Motion to adjourn? Made and seconded. Thank you, everybody.